How do you win a DUI case in Ontario? That's what I'm going to cover in this video. I'm Dan Joffe, DUI lawyer at Nextlaw. Let's get started. One of the most common questions we get from clients is, how do you beat a DUI in Ontario? To answer this question, it's important to understand how our criminal justice system is designed. When you're charged with a DUI in Ontario, it's not your job to prove the DUI did not happen. It's the job of the government lawyers to prove the DUI case against you beyond a reasonable doubt. If there is any reasonable doubt about the evidence or lack of evidence, your DUI charge will get withdrawn. Let me explain in more detail. So first, let's discuss what reasonable doubt means. In every DUI case in Ontario, the Crown must prove every element of the DUI charge you face. In Ontario, these DUI charges are impaired driving, over 80, and refusal to take a breathalyzer test. For each of these DUI charges, the Criminal Code of Canada defines specific elements of the DUI charge, each of which must be proved to convict you of your DUI. And the standard of proof that a judge or a jury will consider is called proof beyond a reasonable doubt. The internet is full of legal discussions about what defines beyond a reasonable doubt. In plain English, beyond a reasonable doubt means that the evidence is so strong that it proves you did commit the DUI. If the evidence is strong but would only lead someone to believe that you're probably guilty, that is not good enough. In that case, a judge or jury would throw out your DUI charge in Ontario. So, in answering the question of how do you win a DUI case in Ontario, it comes down to finding weaknesses in the evidence. In other words, raise reasonable doubts about any element of your DUI charge. And to do this, a DUI lawyer needs to get all the evidence that the Crown will use in your DUI case. If there are weaknesses in the evidence, then a DUI lawyer would bring up those weaknesses with the Crown lawyers. And if the Crown agrees that there are reasonable doubts regarding the evidence, then it is their legal responsibility to withdraw your DUI charge. If the Crown does not agree with your DUI lawyer's assessment of the weaknesses in the evidence, then your DUI case would continue and potentially go to trial. At that point, a judge or jury would decide whether there are any reasonable doubts in the evidence that would result in a not guilty outcome for your DUI charge. Finally, if you've been charged with drunk driving, DUI, impaired driving, or refusing a breathalyzer test, your legal strategy can make the difference between winning and losing. Reach out, let's have a confidential discussion about your case. The call is free and you can book a time by clicking on the link in the description below.